We're ready. Please rise for reconvene.
Please be seated. No. I thought it might be, but I wasn't sure. Okay. Okay, gentlemen, I have the originals here. You each have your own copy, I gather.
Yes, sir.
17 is omitted. And as we've discussed, obviously we don't send ammunition back with the weapon, but neither side has any objection to the weapon being with the jury during deliberations.
State does not. No objection from the defense.
And shall we provide, I think, please correct me if I'm wrong, I think counsel indicated that they had no problem with providing a scrubbed computer for the jury to use for the CDs.
Yes, sir. I don't know what the term scrub means.
Well, I just sort of seized on that, but it's a computer we use that comes from administration. Correct me if I'm wrong on this, by the way, Ms. Rocket. But it comes from administration. So, for example, when judges have to look at materials that otherwise would be inappropriate for the county's computers, we use those to look at evidence and so on. And of course, we used it last spring. The case we sent a computer back, and of course, of course, you understand I was trying to describe this to you, but basically, it can't be compromised in any way, and it doesn't have any extra stuff on it. All they can do is the task, and so it doesn't. You don't run a risk of anything else being accessed on it, internet or what have you.
Your Honor, just in the past and other cases when these programs, and I'm not sure to what level the jurors have as far as getting them up and running, but the state suggests that Mohammed or Danielle Antonio
Yeah.
Be permitted, and they've done it in the past. They don't talk. The jurors have to not talk while they're in there. They just get it up and going for them if they need to. And the state would have no objection to that. Without notice, I wouldn't expect the court would have to call us and let us know that the jury wants help in the computer in some fashion.
But if the jury doesn't ask for help, then
you don't need them.
All right. But what I will do is I will tell the jury when they're discharged that if they need help, just advise Ms. Rocket, and we'll have our systems person come up and help them.
Yes, sir.
All right. Acceptable to you, Mr. Stewart?
Yes, Your Honor.
Very well. Anything else?
Your Honor, one.
Did you wish to withdraw an exhibit?
Yes, that was what I was going to say. There are 2 911 calls, discs admitted. One of them is not complete, and that's the one we're seeking to withdraw. We still need to identify which of the 2 it is to make sure. We think we know, but we want to listen just to make sure. So before the jury gets the evidence, but after closing, we'd like a chance to listen to those and withdraw the one that's not complete.
Agreed?
Agreed.
All right. All right. Gentlemen, unless there's anything else from either side, I will call to the jury.
The state's ready.
Okay, we have the jury, please. Yes. Kathy, you're last.
Yeah, you might. Actually, might.
Thank you very much for your service in this matter and to our system of justice. Members of the jury, at this time, as you know, counsel have rested their cases, including the plaintiff's rebuttal case. I'm going to, in just a moment, read you the court's instructions on the law. You have what I refer to as courtesy copies with you. You can follow along as counsel as I read these instructions, or in the event that the counsel wish to speak to a particular instruction, you'll have those instructions as well in front of you. We doing good on our hearing device? We're not doing good on our hearing device. We're going to stop right now until we are.
I'm hearing you the same whether it's on or not, so.
I think we had a little bit of a mishap yesterday with the channels. Let me see yours. Is that working now? Just okay, good.
How glad are you that you didn't have those earphones on when that happened?
We're good.
There we go. We're good. Okay, that's great. Now, obviously, at any time during the course of this, our proceedings, if any juror doesn't hear or can't hear you, you just raise your hand. We'll adjust accordingly. As I was indicating, you all have courtesy copies of the court's instructions on the law. You'll also have a copy of the original instructions as well to work off of during your deliberations. I'm going to read to you the court's instructions on the law, and you'll of course be provided a copy of the instructions as well, in addition to the courtesy copies, and you use the originals, which are marked as such, as original, for your deliberation. We'll hear first from the plaintiff, and the plaintiff's closing argument may take in the vicinity of 2 hours. At approximately the 1 hour point, we'll just kind of stand up in place and stretch out just a little bit so that we can do that. I'd like to introduce to you Ms. Kathy Shamu, who is here with us today in place of Kathy Marr, who is my usual court reporter, and Ms. Shamu has very graciously agreed to help us today, and we're very much appreciative of her doing that. I'm going to state, just for purpose of the record, and I will probably do this one more time, that during portions of the closing arguments, during the portions in which taped transcripts are being played, Ms. Shamu will not be transcribing those. Members of the jury, I will now instruct you on the law in this matter. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the judicial assistant and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial, unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. A person commits the crime of murder in the first degree when, with a premeditated intent to cause the death of another person, he or she causes the death of such person. Premeditated means thought over beforehand. When a person, after any deliberation, forms an intent to take human life, the killing may follow immediately after the formation of the settled purpose, and it will still be premeditated. Premeditation must involve more than a moment in point of time. The law requires some time, however long or short, in which a design to kill is deliberately formed. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. To convict the defendant of murder in the first degree as charged in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about the 16th day of October 2014, the defendant acted with intent to cause the death of Tara Danielle Nemetz. 2. That the intent to cause the death was premeditated. 3. That Tara Danielle Nemetz died as a result of the defendant's acts. And 4. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. The defendant is charged in count 1 with murder in the first degree. If, after full and careful deliberation on this charge, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crimes of murder in the second degree and or manslaughter in the first degree and or manslaughter in the second degree. When a crime has been proved against a person and there exists a reasonable doubt as to which of 2 or more degrees or crimes that person is guilty, he or she shall be convicted only of the lowest degree or crime. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. To convict the defendant of the first lesser included crime of murder in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about the 16th day of October 2014, the defendant acted with intent to cause the death of Tara Danielle Nemetz. 2. That Tara Danielle Nemetz died as a result of defendant's acts. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. A person commits the crime of manslaughter in the first degree when he or she recklessly causes the death of another person. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that a death may occur. And this regard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness as to a particular result or fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that result or fact. To convict the defendant of the second lesser included crime of manslaughter in the first degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about the 16th day of October 2014, the defendant engaged in reckless conduct. 2. That Tara Danielle Nemetz died as a result of defendant's reckless acts. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. A person commits the crime of manslaughter in the second degree when, with criminal negligence, he or she causes the death of another person. A person is criminally negligent or acts with criminal negligence when he or she fails to be aware of a substantial risk that a death may occur, and this failure constitutes a gross deviation from the standard of care that a reasonable person would exercise in the same situation. When criminal negligence as to a particular result or fact is required to establish an element of a crime, the element is also established if a person acts intentionally or recklessly as to that result or fact. Ladies and gentlemen, jury instruction number 17 was earlier today withdrawn with the agreement of all counsel involved in this proceeding. Accordingly, it was simply removed from your packets per the agreement of all of the counsel and obviously with the court's permission as well. So the next instruction I am reading to you is correctly instruction number 18. To convict the defendant of the third lesser included crime of manslaughter in the second degree as charged in the count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about 16th day of October 2014, the defendant engaged in conduct of criminal negligence. 2. That Tara Danielle Nemetz died as a result of defendant's negligent acts. And 3, that any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, it will be your duty to return a verdict of not guilty. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner. that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. During your deliberations, you may discuss any notes that you have taken during the trial, if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the judicial assistant. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence. These instructions and verdict forms A, B, C, and D. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. When completing the verdict forms, you will first consider the crime of murder in the first degree as charged. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form A the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form A. If you find the defendant guilty on verdict form A, do not use verdict form B, C, or D. If you find the defendant not guilty of the crime of murder in the first degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of murder in the second degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form B the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form B. If you find the defendant guilty on verdict form B, do not use verdict form C or D. If you find the defendant not guilty of the crime of murder in the second degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of manslaughter in the first degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form C the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form C. If you find the defendant guilty on verdict form C, do not use verdict form D. If you find the defendant not guilty of the crime of manslaughter in the first degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of manslaughter in the second degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form D the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form D. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the proper form of verdict or verdicts to express your decision. The presiding juror must sign the verdict form and notify the judicial assistant. The judicial assistant will bring you into court to declare your verdict. You will also be given a special verdict form. If you find the defendant not guilty, do not use the special verdict form. If you find the defendant guilty of murder in the first degree, murder in the second degree, manslaughter in the first degree, or manslaughter in the second degree, you will then use the special verdict form and fill in the blank with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for the question. For purposes of a special verdict, the state must prove beyond a reasonable doubt that the defendant was armed with a firearm at the time of the commission of the crime. A firearm is a weapon or device from which a projectile may be fired by an explosive such as gunpowder. Counsel, if at any time during closings you find that you'd like to have a window opened or there's anything that becomes close or the temperature becomes an issue, because as you know, when the sun occasionally shines here, it does have that effect on us. So I want you to let Ms. Rocket know, and we'll do our best to accommodate that. Members of the jury, may I ask you now to please give your attention to the closing argument of the plaintiff. Sir, you may proceed.
Danielle sat facing that computer screen. She was unaware of what was happening behind her as Mr. Nemetz positioned himself directly behind her with this, an AR-15, an assault rifle. And Mr. Nemetz proceeded to shoulder that weapon, put it from safe to fire, and he pulled the trigger, instantly ending Danielle's life. Everything that Mr. Nemetz did on October 16, 2014 was intentional. The evidence supports that. And as we walk through the evidence and what it supports, one thing is significant, and that is, who is Skylar Nemetz? Right? Because who he is the lens through which you should be evaluating every piece of evidence in this case. So who is Skylar Nemetz? Skylar Nemetz is a trained soldier. By all accounts, a very good one. In fact, in the defense case, it was asserted that he was about to be promoted to an E4. Right? He's been trained on how to deal with trauma, trained on how to deal with stress, trained on death, war, all of those things. But probably most significantly, he's trained on this, right? He's trained on how to use this. He's trained on the rules of handling an AR-15, specifically that this weapon is always loaded. Never orient the weapon as something you're not willing to destroy. And certainly, you never pull the trigger if you're not willing to destroy what's at the other end of that barrel. That's Skylar Nemetz. And that's the lens through which you evaluate the evidence in this case. When you apply that standard and you look at the evidence in that light, there's only one conclusion that this case leads you to, that the evidence leads you to in this case. And that's that Mr. Nemetz intentionally shot his wife in the back of the head. Your common sense tells you that, and when we look at the evidence in that light, you will see that. What I did in this case is want to walk through the evidence of in categories of the evidence you heard, and how there's no other conclusion based on that evidence other than Mr. Nemetz intentionally killed his wife. So, category number 1, Mr. Nemetz rendered no aid to his wife, made no effort whatsoever to even go to her, made no effort to call 911. And that's significant. If this was not an intentional act, if this was an accident that he wants you to believe, any reasonable person who just experienced what he did would do the same thing, especially a trained soldier. They'd drop the weapon immediately. They would go to their spouse. Why do I say that? If this truly was not intentional, he has no idea if he's even struck his wife. He has no idea where she's been struck, the significance of the injuries, whether they're treatable. He didn't do that. Why didn't he go to the aid of his wife? Because he knew he shot her in the back of the head. So let's go walk through what Mr. Nemetz said and the significance of that, thinking always about who he is, what he's trained to do. I'm going to have to. I'm not sure if we need. Sorry, Judge, we tested this earlier and it worked.
That's all right. Let me know if you want me to call someone.
Actually, I think I figured it out.
Just in case we call for decisions. Antonio is on his way up as well.
The point is, I think.
Strasky, we have Antonio Street.
Leave the slides, it's not in there. That works. I don't know if we want to take a short recess, but for whatever reason, the technology is not cooperating.
All right. Members of the jury, we're going to take a short recess.
So this is the same as what's being speaking. I don't know which route to check it.
Let's all be seated, please. before the jury comes back, I'm actually going to put something on the record that I